Good afternoon. It's great to see you all here. I'm Karen Engel, and I teach at the law school, and I also co-direct, along with Neville Hode, who was sitting back there, the Bernard and Audrey Rappaport Center for Human Rights and Justice at UT. It's a real pleasure to welcome you all to our first in-person event since the beginning of COVID. And it's a lot of work to do it this way, but it's really great as well. If anybody forgot a mask and you want one, just to let you know, there's some beautiful orange ones in the back, I think on both sides of the aisle. So I welcome you on behalf of the Rappaport Center, as well as the Lozano Long Institute for Latin American Studies, or LILAS, the Brazil Center, and Texas Planet 2050. And I'm delighted that the directors of each of these programs is with us today. Professors Adela Pineda Franco, who you'll hear from in a bit, Seth Garfield from the History Department, who can wave, and Fernanda Lechi from Engineering and Planet Texas 2050. So thanks so much. We all work together to bring Justice Antonio Benjamin from the Superior Tribunal de Justiça, or the highest non-constitutional court of Brazil, to be with us in residence this week. So he's been here since Friday, but in his office since Monday morning early, and to speak with us today on Can the Law Save Tropical Forests? And I'm guessing it's going to be a complicated answer. Justice Benjamin presents his lecture in his capacity as a visiting research professor at LILAS and the Rappaport Center, as well as a part of Planet Texas 2050's Research Symposium. And they're all wearing name tags, the folks who are joining us from there, which is really helpful. And I'm glad you all found the law school. So this event is special for a number of reasons, not the least of which is that it is bringing together so many different programs across campus to hear a lecture on issues that we're all interested in from multiple perspectives. The LILAS Visiting Research Program provides a wonderful opportunity that not only connects faculty across the region with scholars with similar interests at UT, and our students, but it also connects us to each other. So we're having a reception afterward outside in this cool spring weather. And we really, part of that is so that we can already begin to continue the conversation that we will start here. So it's a really special part of us being here. But this event is particularly special because of whom it is brought to us to bring us together. So Professor Pineda Franco will give Justice Benjamin a proper introduction in a moment. I'll say that he is not only one of the world's leading experts on environmental law and biodiversity, he's a longtime friend and colleague of Texas law, of LILAS, and of the University of Texas more broadly. He taught at the law school for 17 years, and not only did he spend a lot of time here during that period, but he's brought many of us and our students to different parts of Brazil over the years, long before he was a judge, and came here long before he was a judge. Many of our students worked with him doing consumer protection law in the Attorney General's office. They all came back having lost their Spanish and taking up, spending a lot of time in Brazil and using their Portuguese. And this is his first visit for 10 years. But although hasn't been here physically in 10 years, it doesn't mean that the connection has been lost. So many of us have gone and taken advantage of his hospitality and work in Brazil. And most recently in August 2019, which now we look back and say just before COVID, he hosted me and Eddie Shore, who is now a second-year law student in Brasilia, for a Rappaport Center project that we're working on with a number of Quilombola communities. And as many of you know, when he hosts you in style. So not only did Antonio provide us with a car, a driver, office space in his chambers, but he helped set up really crucial meetings with basically all the key players throughout the Capitol. And when Ministro Benjamin calls, they answer, and they did that even before you were a ministro, because he's just so gracious and likes making connections, and has shown over and over that great work comes out of them. So before I invite Professor Pineda-Franco to the podium, I just want to say thanks to the many, many people who made this event possible today. And just to name a few, in addition to those I've already mentioned, Paloma Diaz, who, there you are, is Assistant Director and Faculty Liaison at LILAS, and has been working with this program forever, and really, really facilitated so much of it. Luis Baeza, also from LILAS. Heidi Schmalbach from Planet Texas 2050, who has been great at making sure that this is a part of the symposium. Zach Bleckner, who's the Rappaport Center Assistant Director, along with Jacob Blass, who's our program associate, and then all of our student scholars and interns, but especially Grayson Myers, who's a human rights scholar at the law school, and Hannah Tai. So thank you to all of you for the work that you've done. Zach and Jacob have also been behind the reception that we're going to have. So I'll just tell you now, and then maybe I'll say it again at the end. When you want to go there, you can just head out the doors and take a right, and basically you'll just keep going to the right, but there will be people, and I think there are even signs up now, to help you along the way. And even if you didn't RSVP, please come. So it's now my pleasure to introduce Adela Pineda-Franco, who will introduce Antonio Benjamin. She is Lozano Long Endowed Professor in Latin American Literary and Cultural Studies, and as I've already mentioned, is the director of LILAS. She came to us from Boston University just last fall, and is going to take us to new heights. It's a pleasure to actually meet her in person today, because that hasn't happened until now. So thank you so much for joining us, and I hope that this is the beginning of many collaborations with you.
Well, thank you, Karen, and it's been a pleasure to have the opportunity to meet Justice Antonio Herman Benjamin yesterday for a dinner, and so as Karen said, this is my first year as LILAS director, so I've been learning a lot about our long-standing collaboration with the Rappaport Center. So I am honored not only to introduce Benjamin, but also very happy to be able to continue this relationship with the Rappaport Center. I thank Karen Engel and Nelville Holt for the invitation, because I think we have had a long-standing relationship between the Rappaport and us, collaborating in efforts, bringing students, developing research initiatives, and carry on scholarly and public programs related to the role of human rights in Latin America. Today, millions of people are displaced and died due to pollution, climate change, and the collapse of entire ecosystems. Hence, the most urgent human rights challenges of our era are indeed related to the planetary crisis of the environment. On October 8, 2021, the UN Human Rights Council adopted a resolution recognizing that a clean, healthy, and sustainable environment is a human right for all of us. The abatement of climate change and the protection of biodiversity entail conflicting challenges for the development of Latin America and other regions of the Global South. Therefore, it is necessary to act with single-minded purpose and solidarity to protect and fulfill the human right to a healthy environment for all of us. At LILAS, we want to contribute to find concerted solutions to this planetary crisis by bringing forward Latin American perspectives across disciplines. Today, we are so fortunate to collaborate with the Rappaport Center and Texas 2050, and welcome Justice Antonio Herman Benjamin, who has played an important role worldwide in developing models of judicial action and participation related to environmental conflicts. He is Justice of the National High Court of Brazil, a global leader in the environmental law community, the president of the Brazilian Environment Forum of Judges, director of the Master of Laws program on justice at the National Judicial Academy of Brazil, chair emeritus of the World Commission on Environmental Law, president of the Global Judicial Institute on the Environment, and Secretary General of the International Advisory Council for Environmental Justice of the United Nations Environment Program. He's also a member of the UN Secretary General Legal Expert Group on Crimes Against the Environment, and for a decade, member of the Brazilian Environmental Council. Justice Benjamin has received several awards and honors in Brazil and beyond. He's a knight, a chevalier of the National Order of the Legion of Honor in France, and a commander of the Order of King Leopold of Belgium. He's the recipient of the 2015 Elizabeth Howe Prize for Environmental Law, the most prestigious international distinction conferred upon an environmental legal expert. He's a Goodwill Ambassador for Environmental Justice of the Organization of American States. In 2020, Brazilian scientists named after him a newly discovered species of orchid from the Amazon rainforest, Bulbophyllum Antonio Benjamini. His lecture, Can the Law Save Tropical Forests, is co-sponsored by the Rappaport Center, LILAS, the Lilas Benson Brazil Center, and Planet Texas 2050. Welcome, Justice Benjamin.
Thank you. Thank you, Julia. I probably don't need this one. I prefer this one. Good afternoon, boa tarde, e buenas tardes a todos. I feel, first of all, very happy to be here, but also everything looks strange to me. The way we are behaving, not because we want, but because we are forced by COVID. But here we are. As Professor Karen Engel said, it's the first face-to-face event organized by the Rappaport Center. She told me that I should not thank the main organizers because she'll do it, but I'm a Brazilian. And I have to do it. To begin with the Rappaport Center, this is an institution that I watch being established. And I vividly remember the original difficulties, but at the same time, the huge enthusiasm that both the then Dean, Bill Powers, and Professor Karen Engel had in this endeavor. And it's difficult to find an institution that is more successful in an area that is so complicated, so difficult to work with. The second is Lilas. And I see here not only you, it's wonderful to be introduced by two powerful, globally recognized women. I see not only you, but also I recognize, in spite of the mask, Peter Cleaves, and many other colleagues associated with Lilas. The Brazil Center is sitting somewhere, there he is, with the masks. There are good things, but also bad things. You never know if you are saluting the right person. Seth is someone that Brazil has to be very grateful to, because of the quality of the academic work that he does, but also because of the way he does it. Those are two different things. And he has a passion for Brazil, and no wonder he's married to a Brazilian. But I would like, in thanking the Brazil Center, to thank Professor Richard Graham. His predecessor, many generations back to the very early 90s, that introduced me to the law school and basically said, to the then dean, Michael Charlotte, and then I went through other deans that had this passion for Brazil. Bill Powers, I have already mentioned, Steve Good, I don't know if Steve is here, Larry Sager, John Cohen's there, and the whole community. But Richard said, we need to have not just someone from Mexico, we need to have someone from Brazil. So many thanks to the Brazil Center and to all of you for being here. There are so many friends, and so many friends fluent in Portuguese, including in the Rapoport Center. So you see, we know how to infiltrate. And they all speak Portuguese. I believe Silvia Hendricks at any moment will be speaking Portuguese too. We give her 2 caipirinhas and she'll be absolutely fluent. The students, what a change in the students that we have now at UT. And finally, Planet Texas. I almost said Texas Planet, because if it were, in the early 19s, it would probably be Texas Planet, because Texas was basically the center of the universe, and still is. Everything begins here. But there is one thing that begins here, and this recognition has immense repercussions, academic repercussions, is that Austin and UT is the gate for Latin America. Studies, research, and knowledge. We should not forget this. It has been, it continues to be, and I am sure it will continue to be. So many thanks to all of you. The topic of my presentation is one that may sound arrogant or too ambitious if we don't have a question mark. And I forgot to put the question mark. At least when I send this as a suggestion. And Zach immediately replied and claimed, oh, this is good. Let me start saying what I'm not going to cover. And it's most of it. But what I'm going to cover, hopefully, is still a lot. I will not cover biodiversity. And UT was the first law school in the United States and one of the first in the world to have a course on biodiversity law. And I taught this course for many, many years. And in fact, I learned. The students think we are teaching, but we are learning. So keep in mind that although I'll be speaking about forests cannot be understood in isolation. They are part of something bigger, and bigger not just in science, there's so many sciences here, or from a scientific perspective, but they are bigger from a law perspective. So for the sake of making things perhaps less complex and less difficult, I will focus on forest. I'm not going to focus, and it's clear in the title, on forests in general, but on tropical forests, and within tropical forests, on the so-called rainforests. And there are reasons for this. We all think that those are forests. Put them in the same basket. Doesn't work like that. And if we, with our legal minds, want to regulate them, we have to understand that they can be completely different. Still forests, still trees, but with different needs, different characteristics. So law has to take this into consideration. The other point that I would like to stress that I'm not going to be covering is the international aspects of forest regulation, because we don't have it. But we do have regulation and norms, wonderful norms, protecting biodiversity, and forests come in this big box, but not for forests. This is one of the major failures of the international community. If we were to point out the gaps of the international law, environmental regimes are one, the forefront, forests, second, coral reefs, one inland, another one in the oceans. And both of them very, very threatened by us humans. Finally, in this sort of mapping out how this conversation will be, I'll speak for only 40 minutes, and then we open up for questions. And there'll be questions that I won't know the answer, and there'll be questions that I know the answer, but I cannot share with you. But I'll be frank and say I can't speak about it, since I am a judge. I start with the misconceptions in law, but in other areas of knowledge. We have to begin with the right questions, but that's not enough. In proposing the right questions, we need to exclude the misconceptions, because we might get the wrong questions and then the wrong answers. The first misconception, I'll mention just two. The first misconception is one that I have already mentioned, and I could, later on I'll say more about it, is that all forests are equal. And I give you an example now. 1 hectare, there are many ways of giving those examples, and it's nice if I had those things on a screen. So 1 hectare, and the scientists that are here will be able to correct me if I'm wrong, has 1 hectare of tropical forest has 400 at least species of trees. And in the United States, the same 1 hectare will have 20 species of trees. This has huge implications for law. For example, and I will elaborate a little bit later, restoration. Just look at the numbers in the United States. Forests for the past 50 years are coming back. There are states that now have 80% of, or countries like Japan, of their area covered with forests. Temperate forests. What about when you lose, and I'm talking about a single 1 hectare of tropical forest, and in that package, most of it, science is not even aware of the components that are there. Science is aware of a good number of the tree species and other species, but there are many more species, and some of them are invisible to us. So we lose what we don't know. And I said this in one of the judgments of my court about a biome in Brazil that Brazilians are not aware of, and very few scientists. So we lose what we don't know, and if we don't know, we judges and the legal community in general cannot properly regulate and restore, since you don't know what was there before to begin with. The second misconception is one that has a clear connection with human rights. And there are several experts here on human rights, including the director of the Rappaport Center, but I see Professor David Raban, I see Professor William Forbath, I see Professor Jane Cohen, and several other colleagues with the mask I can really identify. They have a strong connection with human rights in their respective legal disciplines. It is the misconception that this deforestation is caused by the millions of pua. This is absolutely incorrect. And those millions of pua are used as smokescreen to justify laws that allow for deforestation and allow for what we call regularização. How do I say this in English? Legalization of crimes against the forest and against humanity. Oh, it's the poor. No, it's not the poor. Are those Brazilians, those Latin Americans, and in Congo and Indonesia, in other parts of the world that I have had the privilege to see with my own eyes, that have their kids in boarding schools in Switzerland and bank accounts. So it's not the poor. Because the next question then is, how can we make sure that environmental law and the protection of forests doesn't become an impediment for people that are so poor to become finally rich? They will never be rich through deforestation. I don't know, and I have traveled all around the world and my country. I have never found a poor peasant that has become rich through deforestation. They can guarantee their survival. But when you see massive deforestation is not done by those people. And this misconception is one that has horrible pervasive impact in the way that we think about law and law implementation. I said I would mention two misconceptions. I will add one last, if you allow me. And here is, you have the two extremes. We should not be afraid of extremes but we should deal with the extremes. But there are extremes that are completely incompatible with civilization and with the rule of law. So those extremes we cannot allow. Fascism, for example. But in environmental law and in conservation, you have, different streams in what would be the arch of legitimacy. All legitimate ways of thinking about the same problem and solution. So one extreme is what I call the optimist legal extreme, is to think that law can solve everything. And by consequence, that judges can solve all environmental problems. If you have good judges, they are trained, they are independent, they work with integrity, the environment will be safe. No. The other extreme is to say that this is not the place for law. Let the market decide. The problem is that there is no market. And there are economists here for many of the things that we are talking about here, and not just the intangible components of the environment. So, as in everything, we tend to, as the Japanese have this wonderful word, izonome, which means the middle. The Chinese do have another word for that. So we have to look for something in between, which is law is absolutely important, but it's part of something much bigger. And we are going to discuss some of those aspects. So let's move into forest and law, which is the topic of my presentation. This is a very old story and relationship. The law school, have been so many changes, and so perhaps Sylvia, you can bring back that beautiful picture that was well framed, and I think just across the corridor where you have the Rappaport Center, that had the Magna Carta. I couldn't find it. I'm sure it's here somewhere. It was a reproduction, of course. This law school has many antiques, but it is a reproduction. But a beautiful one, and in fact, two texts, one next to the other. One is the Magna Carta that all of us discuss and teach about. And the other one, and I'll give you the name in English, although it's in Latin, it's the Charter of the Forest, Carta Foresta, of 1217. They were issued at the same time, companion documents. It's one example. There are many, many examples in all legal systems in which you find direct regulation of forests. And in this case, together with the Magna Carta, you see it's really not just an administrative, a royal decree. In Brazil, perhaps Seth and the other historians know about this, and I have cited in another opinion of the court to show that we are not inventing the wheel. In 1542, it was issued by the King of Portugal a decree protecting the Brazil wood. And another one in 1605 that is similar but of a different nature. But it's not about this type of regulation that brings us here today. This regulation was either to protect the property of the king, and remember, the king and emperors needed to build ships and warships. So it was necessary to protect those trees, royal property. It was also to protect the forest, not because of the forest, but because of the wildlife, the royal forests. And that's the reason why you have the Carta Foresta together with the Magna Carta. Because the Normans brought this vision that all forests should be royal because that's where wildlife was, and the king and the nobles needed to hunt, not with the exclusion of everybody. And no wonder it's so difficult in Europe. I will not extrapolate to Texas or the United States to regulate hunting, because that was seen since then as a conquest of the free men to go into the royal forest and hunt. That was a symbol of privilege, or an example of privilege, then shared with everybody, but with catastrophic results for wildlife and forests themselves. What is different now is, first of all, that deforestation is massive. One can say, well, look at what happened in the United States. It was massive deforestation. Don't use this example. There are segments of those that are in power in my country, and you see that I'm very careful with the way I say things there, and in other countries that use the argument that Europe and the United States clear their forests in order to be developed. So they are rich and developed because they clear their forest. And now they want to impose, as a sort of green new imperialism, on other countries the protection of their forests. So they did it in a massive manner. We can do it in a massive manner too. Well, it was not done in such a massive manner in such a short period of times. Just look at the history of the Roman Empire. How the fighting was not just in the battlefield, the fighting was to conquer the forest, where the Germanic tribes were infiltrated. It took ages. Now we are clearing, and I'll save you from the numbers. We are clearing forests at a speed with a technology that we didn't have before. No period in history has watched this phenomenon. Deforestation, yes, but not with those features. It's also, from a legal perspective, something that will have consequences. Because it will have consequences for judges too. If you are doing this in a massive manner, measures to protect the forest that focus on the local will fail. I have seen, for example, in my country, a beautiful forest on one, an Atlantic forest in this case, on one side of the river, protected, on the other side of the river, not protected. You have one judge with jurisdiction in one side and another judge with jurisdiction on the other side. This is a recipe for failure. If you have a judge that is not so knowledgeable or just lazy on one side, and another one that is the opposite, the other side, the result on both sides will be different. The second the second major difference between deforestation in the past and regulation of forests in the past and nowadays is that we have been able to, and this for you coming from Mexico, and we were talking about it, we have been able to do something that if we were to propose 40 years ago, we would be called green communists, which is to include in the legislation, and in some cases in the Constitution, that private property brings with it not just rights or social obligations, a contribution of the Mexican Constitution and then the Weimar Constitution, and it's everywhere in the world now, but an ecological function as well. And this goes to the core of the problem. And it's not that we are challenging that this concept of absolute property rights doesn't exist, and it has not existed for ages, at least in Latin America and in many parts of the world. For example, the regulation of the labor market, really, or contracts, protection against unfair contract clause, and many, many examples in the environment too, through the concept of the ecological function of property rights. The good news here is that I am saying this not as I would do 27 years ago, or when I started teaching here, just, as a reflection, a theoretical reflection, but courts around the world are doing this and saying expressly, both constitutional courts and non-constitutional courts are justifying measures to protect forests not under a sort of external rationale, but an intrinsic rationale that is attached to property rights. So you still have all the rights that come, as you say in common law, with the bundle of rights of property, but each one of those rights are conditioned by the ecological function of property. No one has the right to destroy the environment for the sake of destruction. This sounds really revolutionary, but it's not. If you look at other areas of law, does anyone here, no, I should not ask this question about here, because Houston has no urban planning rules, at least didn't have. But in most parts of the world, nobody will ask, why? This doesn't sound legitimate, doesn't sound fair, that I have to leave a certain space in front of my house, or that I have limitations on height of buildings. So why is that we accept this, and the same rationale would be like a legal Martian arriving if you are dealing with rural property? One of the lessons of law is that you differentiate when differentiation exists, and you do not differentiate when there is no difference. And in fact, it's quite the opposite. You should be having a stronger type of regulation in that area. Finally, in this, and I'm already moving towards the middle end of my presentation, is the connection of the protection of forests with human rights. So I repeat: 1, massive; 2, the recognition of the ecological function of property rights; and 3rd, an acceptance. And this took a long time, that the protection of the environment cannot be done separated from the protection of human rights or fundamental rights. In fact, protecting the environment is a fundamental right in itself, as my constitutional colleagues would say. And I was I was a witness of how uneasy we felt about talking or discussing environmental issues and including a human rights connection. In some places, we were directly instructed, don't mention human rights. But how can you speak about the right of information or to information, the right to participate, the right to have a fair judgment or a judge that is independent and behaves with integrity, and still think that you are protecting the environment? You cannot speak about those things. There are colleagues here from the government school. So it's impossible to separate those things. So there are countries in which I work, and I will continue to work in spite of the difficulties, in which this is a problem that we face. Countries that, and you see people, even in the government, that want to protect the environment, but they don't have the basic freedoms that we do in systems that operate under the rule of law. This is a connection that has become more acute recently, especially in Latin America, and I suppose the UT system is working in this area with the so-called environmental defenders. People are being killed. People are being threatened. They have to leave where they live, where they have their residence, with their families, because they protect the environment. Imagine this. Someone that is doing what all of us should be doing together. It's doing on our behalf and on behalf of future generations, and instead of recognition, they are assassinated. I cannot imagine a stronger connection with human rights, or rather with the violation of basic human rights, than in the case of environmental defenders. Let's move to the conclusions. And here, some challenge and trends. The first challenge is one that we law professors and scholars in general love, which has to do with the conceptual framework of what we are doing. Because in some areas, it's not just, do you say in English, to retouch something? Just, put a little bit of paint and repair? No, it's a complete change of paradigm, of legal paradigm. I could mention several of those, but for another place and opportunity. In law, I can give you one example that's happening as we speak. The Constitutional Convention of Chile is including in its text a recognition of personhood of nature. Because when it was Bolivia, Pachamama, it was Bolivia. It's, they don't know what they're doing. We have those things among us too. It's not just the North and the South. Or Ecuador, again, they didn't know what to do. But when you see countries in Latin America that have a strong legal tradition that does this, and in other parts of the world too, we are in front of fundamental shift. Not shallow, really deep. Professor Christoph Stone, one of the persons I admire the most, visited me in Brazil, passed not long ago. You all know that he wrote this wonderful book. It became a book. Should Trees Have Standing? I don't think he ever imagined that would have global repercussions. And it did, and it's still in the process of being adopted in many parts of the world. Germany, at this right moment, and as you know, in legal theory, when the Germans move, this has a lot of meaning for the whole world, with the exception of the United States, because the US doesn't recognize it directly, but it does have an impact here too. And even in France, although again, they will not recognize that this comes from Germany. Then they infiltrate in the European Union, and then everything becomes nice. Let me mention a second challenge, which is cultural. And I know many of you work with either in sociology, anthropology, and other political science. Forests everywhere in the world, for us, not for other people, the ones that have lived in the forest, have been seen as the enemy of the people. And this has infiltrated, and it's part of the DNA of our culture. The stories that we tell our children. The forest is a place not for us. And if it's not for us, get rid of it. Of course, this has changed enormously. And in a way, we are now seeing the forest as the people that live in the forest. I don't know if Patty Smith is here. There she is. And her colleague. I've just spoken about Germany. So they study the language, some of the most complex language in the world. It's not the Navajo. The Navajo is almost like English to learn compared to those language where you have very few people. But if you look at the beautiful books that they put together to teach the kids, the forest is not the enemy. And it's not because they made up that. The kids did it. And the drawings and everything. Please share with them, those that would like to see this. I'll say something that my colleagues and friends know that I repeat all the time. When I see something that is really exceptional, I say, I felt like a bacteria, this tiny, before those people. Because it's absolutely extraordinary. So this cultural aspect constrains law. And we could explore, I could give you many examples in judge making in which this comes live in front of us. And we have to find a way to overcome, or the ways to overcome this. But for Brazil, and then I'll call the Brazilianists here, there are so many, there is one extra complication. And we Brazilians, most Brazilians, think that this is a good quality of our character. It's the so-called jeitinho. And the jeitinho is, and I recommend an article written by Keith Rosen I think in 1971. The article is called Brazil's Institutional Bypass of the Formal Legal System. It's a way to describe something that's negative in legalist terms. Brazilians say, oh, we always have this jeitinho. And the jeitinho means that you can twist the law, and as opposed to adapting behavior to law, you adapt the law to behavior. And this is the defeat of the legal system. If you do it, because usually you are going to twist in a favorable way to you, to protect you, your family, your friends, and twist it in the opposite direction to increase the burden on the weaker party, to punish your adversaries, not even enemies. So the jeitinho we have in Brazil to say that the jeitinho is a perversion of the rule of law. But my colleagues and my friends, my mother, they all think that the jeitinho is a nice component of Brazilian culture. The last challenge, there are so many that I would like to mention, is implementation. And here, in thinking about this, when I was preparing this short lecture, I thought that I would provoke the UT scholars to make a comparison between how we dealt with anti-slavery legislation and the protection of the environment. In Brazil, the Brazilians and the Brazilians that are here know that we have an expression, we say, é para inglês ver. It's for the Englishman to see. Very few people know the origin of this. The origin is that in 1831, an imperial law was approved. So Brazil was already independent, for those that are not too familiar with Brazilian history. Under huge pressure from England. And this law prohibited the transatlantic slave trade. From that moment on, it was not trade anymore, it was trafficking. And to me, it was always trafficking, in spite of what the legislation said. But in legal terms, it became illegal. And it took decades for this law to be implemented. And there are documents and reports from that period in which city governments or even governors would petition the Senate or the Parliament of Brazil. We had two chambers too, during the empire, for the suspension of the law. And one of the arguments was that it's impossible to implement this legislation. It's the same type of argument that we see in the environmental context. But we, experts in environmental law, don't make this connection. And frankly, until I was preparing this talk, I never made this connection. And to me now, I might be wrong, but to me, the connection is absolutely evident. It's the same thing, with the exception that we are not dealing with people treated in an unfair, illegitimate, anti-civilization manner, but we are dealing with the community of life. And the community of life is much more diverse than us human beings. I end with the trends. First, something we all know, that there is a growing global awareness with legal consequences. The European Parliament, just about a month ago, it's available online, the debate that we had in academic debate in an event organized in the Senate with our German colleagues, a young member of the European Parliament, the youngest chair of an important committee in the European Parliament, was one of the speakers, and she explained what the European Parliament will be doing soon in order to limit the import of especially agricultural products that come from areas that have been illegally deforested. So this awareness, it's not just, oh, we are all, for the protection of the environment, it's having international and national consequences. The other trend that I would point out is that, and I will end with this, is the development of new and unique legal concepts. So at the very end of my presentation, I go back to the opening of my presentation, when I stated the obvious for the scientists, but not so obvious for all of us, the others, the non-scientists that there are forests and forests. In other words, if in the area of pollution control, we could easily transplant legal instruments from one legal culture into the other and vice versa. Example, environment impact assessment. Or even in civil procedure, public interest litigation, class action and so on, citizen suits and so on. For the protection of forests, we have to develop unique instruments for those or coming from those countries where those forests are based or exist. And I'll give you examples. The first I have already alluded to, the principle of the ecological function of property rights. There are dozens of cases now. It mainly began in Latin America, mainly began in my court, but now in Argentina, Chile, Peru, Costa Rica, Mexico, Indonesia, India, using this concept openly because we judges have now our own community for discussion and debate and learning, the Global Judicial Institute on the Environment. So we are doing it's not transatlantic, it's global, a global dialogue among judges, and often those judges will be applying concepts that, although not clearly stated in their legal system, they are compatible with their legal systems. And one of them is the ecological function of property rights, that you can take either from the environmental legislative framework or even better from the Constitution, and this is happening. The other one, and I will bother you, those that are not from law, with Latin terms, but I will explain. The other one that is also a recent development, and it's being used around the globe through this dialogue among judges, is the nature, how do I say this in English? In law, we have two types, very well-known types of obligations. We have real obligations and we have personal obligations. This comes from Roman law. But there is something in between called propter rem. It's a sort of amphibious. Has some of real obligations and from personal. But the main characteristic is that it attached to the land. So a mortgage, for example. If you sell your property, the mortgage goes with it, at least in civil law countries. I'm not sure about the common law, but it's probably the same. It's not personal. We have developed this concept that is now pervasive, especially in Latin American judiciaries, that the obligation to protect forests is propter rem. The consequences are not just theoretical. Oh, it's beautiful to use Latin. No. Two main consequences. One, often you would have a case, 100,000 hectares cleared by someone, and the defendant would say, Your Honor, sorry, I do recognize that this is there, but I bought the land already cleared, and here are the satellite maps. What this argument does is to break the causation link. If you have propter rem, it attached to the land, doesn't matter. You buy the land, you buy the rights associated with the land, and you buy the ecological obligations coming from the ecological function associated with the land. The other consequence is equally relevant. The other argument would be for the same defendant, Your Honor, I know the land is cleared. Your Honor, I did it. I'm happy to confess. But I did this 30 years ago, statute of limitation. We could solve this problem through other legal mechanisms, but in civil law countries, those other legal mechanisms that I'm not going to elaborate on are considered unconstitutional. So now you have, in many countries, especially in Latin America, but again, it's popping up in other parts of the world, the proper rem nature of ecological obligations. And my very last point among those developments of new and unique legal concepts is it's the last time you hear me saying something in Latin. It's the in dubio pronatura principle. It's not written anywhere, and we judges are using it. And there is a whole, it's not just using, we justify, and we can justify in our legal systems why this is there. And it means basically that, as it happens in criminal law, if you are in doubt, protect nature. Protect, and not just nature in general, but the elements of nature. Water, wildlife, forest, and so on. And this has been more and more elaborated and sophisticated, and a former intern of mine, American, wrote a beautiful article on it, and it's available in one of Environmental Law Review. I said I would speak for 40 minutes. I went beyond it, and I think it's time to stop. And again, it is a great pleasure to be back, to see all of you, to see the law school, the university. As I told Karen, and I think I told you yesterday too, I feel at home. Isn't this great? You are away for 10 years, and then you come back, and it's home. Thank you very much. Yeah. Yes.
So we have time for a few questions.
Hello, and thank you for a wonderful talk. I'm an ecologist, and I work in the area of spatial processes. So, familiar things like rivers flowing a lot across landscapes, fire propagating, birds migrating, and more recently things like plants and animals and people that are escaping climate change. I was just remembering the only other time I've been in this building, I came across campus from the biology department to talk on a panel about our work we'd done many years ago on the impact of the border wall on species. And so I would just say that ecology is intrinsically, from our perspective, transboundary. And I was wondering if you had thought about this and how it might integrate with the concept of land ownership and property rights.
Well, many, can you hear me with this thing here? Many thanks for asking a question and this question, because it allows me to elaborate a little bit on a few things that I mentioned briefly. here you have a complete disconnect between the legal system and reality. I gave you the example of the judge that is on the one side of the river, the Black River, and Professor David Raban visit, and the other side, because we organize our courts through the division of the territory. And this is understandable, because the territory for its use is also divided in pieces, and those pieces are assigned to individuals and to corporations for the use. The question is, how can we are never going to entirely deal with this disconnect, this gap. How can we address the most perverse aspects of this contradiction? One, and it is a system that exists in many countries already, or I should not say many, but several, the establishment of environmental courts. And it's not just in the South that we have environmental courts. Even in the United States, Vermont has 2 environmental judges. And Hawaii now with several environmental judges, and I've had the pleasure to conduct capacity building to those judges. But Sweden has a system of environmental courts. And here, the environmental judges go beyond the boundaries of jurisdiction. And it's one possibility. This possibility in dealing with the institutional aspects of your question. But what about the legislative aspects? In some parts of the world, you have specific legislation for specific biomes. And Brazil is an example. We have a law for the Atlantic forest, separated from the forest code. So the forest code applies to the Atlantic forest, but in addition to this, you have specific provisions for the Atlantic forest, because the biomes are very, very different, or can be very different. And within biomes, you have so many different types of ecosystems. I remember just an anecdote. I don't think I told you any anecdote. I was with colleagues from the law school, and I always, for some strange reason, I come from the countryside of Brazil, the dry lands, I always admire mangroves. And mangroves, you know, are not exactly the most beautiful place in the world. So I organized for those colleagues and their children a visit to the national parks between Paraty and São Paulo, the Emerald Coast of Brazil, wonderful. And I included a visit to a mangrove and a canoe visit. 15 minutes later, and I was at the peak of my excitement, explaining, with the biologist, how those few species were so relevant, and the salt water and everything, and I hear one of the kids saying, "Mom, can we go back to the beach?" So yes, and that mangrove is part of the Atlantic forest. So we can deal with this at the legislative level as well. But again, all this is very complicated. But at least we know that, one, we need to do something, and second, it's possible to do something. Incidentally, I don't think they will mind. I can reveal the identity of the kids and the parents. It was Bill Powers and Kim, I don't know if Kim is here, and the kids.
Thank you very much for your talk. I read an article recently about an advocate for, or at least he portrayed himself as an advocate for indigenous people in the Amazon. And he was going and confronting the people that were inside the Amazon that were there to protect the environment, and also the agency that was dealing with the indigenous population. And it was ambiguous to me what his real interests were. He had a lot of training as an anthropologist, but the thrust of what the article was saying was he was advancing the interests of indigenous people to develop the forest because they didn't have anything else. How does that kind of advocacy play? I mean, I prefer that indigenous people, we found something else for them to do than to cut down the trees, but how does that kind of advocacy and that kind of issue play out in the context of your thinking?
Thank you. This is a very complex issue. And there are several dimensions for this issue. The first one is we don't want indigenous people to do things because we think they are correct. Those things. They have the right to decide about themselves. And this is completely compatible with the notion of sovereignty and the nation state. It's a single nation, at least in my country and in other countries in Latin America. The other thing is that we see the appropriation of the discourse that, oh, I want the indigenous communities to be as rich as we are, plant soybean, clear the forest, have cattle, but basically the cattle and the soybean will belong to somebody else. Or I would like to see, I'm not mentioning anybody in particular, no leader of any country. Or I want indigenous communities to mine their diamonds, the gold, the uranium that is there. Well, it will be mined not by them. It will be sold not by them. So we have to be careful with who is using this discourse. Whether this discourse is being used as a manipulation of the truth in order to advance the final conquest of Indian tribes. I'm sorry, the territory of indigenous communities. We have to be very careful with this. I am of the opinion that, and this is the opinion of all the experts, but as somebody that comes from law, I am of the opinion that the first thing we need to protect is the territory. But it's not enough to protect the territory, and that's why with the Rappaport Center and UTE and Patty and other colleagues, we are now discussing about the protection of language per se. because language is the way in which we communicate among ourselves, and language is the way we communicate with the gods and with our ancestors. Imagine this. So it's not enough to protect the land, because the land without the language, a lot will have already been lost. Let's be careful. Let's not let, it's important that we don't let the poor to be used by the rich and the powerful. And it's important that we don't let indigenous people be used by those that want to destroy their land. But they cannot say this openly. But thank you very much.
Hi, Antonio.
Hi, Jane.
So, in the United States and in other parts of the world, other kinds of conceptual moves have been made recently, are being made, in favor of the general idea that protection has to be found, protection has to be secured. I'll just offer two of those, and I'm going to set the table for you by mentioning them, and then ask you whether you're tempted to use either of them, and whether you're interested in building a sort of cross-cultural toolkit that sort of takes everything from everywhere, or whether you think there are reasons to limit that toolkit to certain items, such as the ones you mentioned. I don't know what's exclusive and I don't know what's inclusive. I want your guidance. So in the United States in particular, the idea is that we have valued forests and other natural goods for the wrong reasons. We've valued up clear cutting, we valued up lumber, we valued up use over existence, use over conservation, you know that. So the big move has been towards ecosystem services and valuing what we keep rather than what we use, and then setting off these values against each other and hoping that ecosystem services win and the other values lose in some, equation or balancing that law can do. The second possibility is to take the rights system, and this is the Chris Stone idea, and cause it to mature in favor of not just jurisdictional rights, but actual substantive rights for rivers. That's the New Zealand move. And now in Florida, the idea that a lake is a person, a lake should be able to be protected in its own terms. So we have the legal personhood move, and we have the economic valuation move. And you didn't seem to be tempted by either of those when you're building your new toolkit. And I wondered whether you're really not tempted, or you think of them as less useful than the tools you're building, or what's the relationship between these other tools and yours?
Well, thank you very much. First of all, about ecosystem service. This is another way of saying, or at least it's a component that has to be taken into consideration within the concept or the principle of the ecological function of property rights. So we are dealing basically with the ecosystem service. But service to whom, right? And so we have to again, be careful here. We are not taking just a utilitarian approach, because we'll be around the same. There is much more in protecting forests and protecting habitat than protecting humans. I believe we all agree that it's more than humans, it's the community of life, because we depend on the community of life. So it's not just an ethical assumption, it's a legal assumption that is slowly becoming more accepted. The second point that you made, and you mentioned New Zealand, I could add a third, which is the public trust doctrine that developed in the United States. But we don't use the public trust doctrine because it's not necessary. And the public trust doctrine in this country has been, or is being, weakened. South Africa imported it, put it in its constitution because of Joseph Sachs. But basically, we have, I think, more possibilities with those new tools and legal concepts that don't bring with them too much of a history. And the public trust doctrine comes, it's interesting. We hear very often, common law, civil law. Civil law comes from Roman law. But in property law, the most Roman law influenced system is common law, because the public trust doctrine comes from Roman law. The Normans brought it, and then we lost it in civil law countries with other concepts that developed later. So I consider those two, plus the third. But what I try to do here is to explain, and those are not experiments that are happening around the world, but things that are already been applied by the courts. And of course, I could say much more, but the time is limited. But many thanks.
Thank you.